NASCAR has been rocked by an unprecedented legal showdown between basketball legend Michael Jordan's 23XI racing team and NASCAR itself. This bitter battle began when 23XI Racing and Front Row Motorsports took NASCAR to court over alleged monopolistic practices, creating what many are calling a David versus Goliath confrontation that could reshape the entire landscape of stock car racing. But what does a veteran like Michael Waltrip think about this high-stakes legal drama? Let's dive straight into this. Michael Jordan's 23XI Racing, co-owned with current driver Denny Hamlin, joined forces with Front Row Motorsports to file an antitrust lawsuit against NASCAR on October 2, 2024. The teams accuse the sanctioning body of creating a monopolistic system that suppresses fair competition and limits team profitability. At the heart of the dispute is NASCAR's charter system, which has been in place for nearly a decade. The system guarantees charter teams racing spots and financial benefits, essentially functioning as a franchise model. However, when NASCAR proposed an updated model for 2025 that would limit teams to holding a maximum of 3 charters each, the conflict erupted. The timing couldn't be more dramatic. While powerhouse teams like Hendrick Motorsports, Joe Gibbs Racing, and Team Penske each currently hold 4 charters, 23XI Racing and Front Row Motorsports saw an opportunity to challenge what they view as NASCAR's iron-fisted control over the sport. "I wouldn't have filed it if I didn't think I could win," Michael Jordan declared before last year's race at Talladega Superspeedway, showcasing the same competitive fire that made him a basketball icon. Amid this legal firestorm, two-time Daytona 500 winner Michael Waltrip has stepped forward with a statement that cuts through the noise. In an exclusive interview with Essentially Sports, the race commentator delivered his unfiltered take on the lawsuit. Waltrip said, "It's a big deal between Front Row Motorsports, 23XI, and NASCAR. I'm not taking away from the importance of the lawsuit. It's white noise." Waltrip elaborated, "To me, and I think for many of the race fans, it's white noise. They'll figure that out. There's going to be fans in the grandstands every Sunday. It ain't going to end NASCAR, and it's not going to end the team model." This statement reveals Waltrip's confidence in the resilience of the sport, even as the legal battle threatens to upend its economic structure. While recognizing the significance of the lawsuit, Waltrip maintains that the on-track action will continue unaffected by the courtroom drama. "I care from the aspect that I want to see how it all turns out, but as far as enjoying a weekend of racing, it has nothing to do with it for me," Waltrip added, effectively distancing himself from the conflict while acknowledging its importance to the sport's future. The lawsuit, spearheaded by Michael Jordan and his renowned attorney Jeffrey Kessler, aims to challenge NASCAR's authority and potentially reshape the sport's landscape. For Jordan, this isn't just about business, it's personal. Jordan told this to Fox Sports prior to the Talladega race on October 6. "I did it for the smaller teams as well. It's not just me. I think everybody should have an opportunity to be successful in any business. My voice is saying that it hasn't been happening." The basketball legend's winning mentality isn't just limited to the court. He's often heard saying, "and I took it personally," using any form of disrespect as motivation to push harder for victory. Now, he's applying that same determination to his racing team's legal battle. Jordan has publicly criticized NASCAR's revenue distribution model, accusing the France family of acting as monopolistic bullies. The current split gives 65% to tracks, 25% to teams, and 10% to NASCAR itself, a formula that Jordan's team is fighting to change. Even as the lawsuit proceeds, Jordan has signaled his financial resolve by purchasing a $70 million Gulfstream G650ER with custom livery. The message is clear: he's in this fight for the long haul. The legal battle has taken several dramatic turns. Initially, there was uncertainty about whether the teams would be allowed to compete during the proceedings, but after a district judge granted a preliminary injunction in favor of the plaintiffs, the teams were permitted to race as chartered entries until a final ruling is reached. Judge Kenneth Bell's ruling was a significant victory for 23XI Racing and Front Row Motorsports. The injunction requires NASCAR to allow the teams to sign the charter agreements they were offered in early September and approve the transfer of a charter each team plans to purchase from Stewart-Haas Racing. To obtain the injunction, the teams needed to prevail on 4 factors, including likelihood of success and irreparable harm. The judge ruled that the clause in the charter agreement that released NASCAR of legal claims would likely be considered unlawful. NASCAR later responded by filing a counterclaim with the U.S. Court of Appeals, arguing that the ruling lacked fairness. The sanctioning body defended its authority to set the sport's rules and denied allegations of fostering a monopoly or unfair practices. The legal maneuvering intensified when NASCAR filed a motion to amend its March counterclaim, citing over 200,000 pages of emails, texts, and memos allegedly proving collusion between the teams during charter negotiations. The lawsuit has also dragged Formula One into the mix. 2311 Racing and Front Row Motorsports are seeking assistance from Liberty Media, F1's owner, to expose NASCAR's alleged monopolistic behavior. The teams have filed court motions to convince various sports leagues, including F1, to comply with previously issued subpoenas. They're requesting financial information from Formula One, as well as the NFL, NBA, and NHL, to compare revenue-sharing models. Plaintiffs seek 4 categories of information showing team and league revenues and how those revenues are split between the league and its teams. The teams write in their brief to compel the NFL, NBA, and NHL. That information will enable plaintiffs to perform a yardstick comparison between the other major professional sports leagues, where competition is not precluded, and NASCAR, where exclusionary conduct has been used to unlawfully maintain a monopoly. However, things aren't off to a great start. Formula One has refused to produce the requested information, leaving 2311 Racing and Front Row Motorsports frustrated. Both teams claim that F1 has no valid basis for its refusal, even though their yardstick comparison is a bold request. NASCAR's 200,000 pages of evidence focus heavily on communications between 2311, Front Row, and Curtis Polk, Michael Jordan's business manager and 2311 investor. The racing body claims the documents confirm that Polk was the ringleader of the concerted effort to set compensation received by the teams, boycott NASCAR events, interfere with NASCAR's negotiations with media partners, and reach unlawful agreements. The filing read that those documents indisputably confirm what NASCAR alleged in its counterclaim. 2311, Front Row, and Curtis Polk knowingly entered into illegal agreements with other teams on issues such as fixing the compensation that they received from NASCAR and allocating how that compensation would be divided among the co-conspirator teams. NASCAR attorney Christopher Yates doubled down, telling the Associated Press that Polk doesn't understand the sport and attempted NBA-style tactics that are not appropriate in NASCAR. But 2311 and Front Row have dismissed the motion as an act of desperation. In a March filing, their attorneys argued joint negotiations aren't illegal. NASCAR's retaliatory counterclaim is an act of desperation that cannot withstand a motion to dismiss. 2311 Racing states in its response, it does not allege the facts necessary to state a claim. Instead, NASCAR is using the counterclaim to engage in litigation gamesmanship, with the transparent objective of intimidating the other racing teams by threatening them with severe consequences if they support plaintiffs' challenge to the unlawful NASCAR monopoly. As the lawsuit unfolds, co-owner Denny Hamlin has chosen to stay on the sidelines, focusing on his racing career and the upcoming championship races. Hamlin said, "There's nothing I need to do for the next few months while things continue to proceed. So it's a good time for me to focus on being a driver and trying to win as many races as I can." Hamlin is focusing on the Cup Series, having won races this season, and looking at the championship races. With 9 races already completed, there's plenty more action for fans to look forward to, and as long as the court drama doesn't spill over onto the racetrack, it remains just background noise for many like Hamlin. This legal showdown is more than just a contract dispute. It's a battle for the very soul of the sport. The teams argue that a premier stock car racing series must have premier stock car racing teams to have a premier stock car racing product.